We are here for oral argument in case number CV220709, Medina v. Chee et al. These proceedings are being video and audio recorded and live streamed. So we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Counsel for appellees, I don't know if you plan to split your time or not, but there's 20 minutes total. Also, please keep in mind that we have read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
May it please the court. My name is Michaela Krass, and I represent the appellant, Claudia Medina. The only issue before the court is whether the state has subject matter jurisdiction over a collision that occurred on a state-controlled U.S. highway. By dismissing this case for lack of subject matter jurisdiction, the trial court found that Navajo Nation has exclusive jurisdiction, meaning the state has no interest over a collision caused by a drunk driver on a U.S. highway simply because the driver is a tribal member and the collision occurred on a portion of the highway that runs across Navajo Nation. There are three reasons. Well, let me go back. In finding that the tribe has exclusive jurisdiction, the court failed to balance the tribe's sovereignty against the state's interest in regulating its highways. There are three reasons the state's interest is sufficient to give it jurisdiction over this case. First, most of the tortious acts leading up to the collision occurred on state land. Second,
Can I jump
yes,
in there, counsel?
please do.
So you're talking about the negligent entrustment, correct?
That is one of the things that absolutely happened on state land.
So it's an interesting argument to me. Is it fair to say that the tortious acts occurring off reservation land and then going onto reservation land, that argument wasn't necessarily raised in the Superior Court or in opening brief?
That is a fair statement. That was raised in response to Century's argument that this conduct occurred solely on tribal land.
And so is that waived? Is that issue waived here?
I think I can respond to the cases cited by Century and relate them to our case. I think it's just another way for the court to say we have jurisdiction over this case.
Okay, thank you.
Second, the tribal court does not have exclusive jurisdiction under the Williams v. Lee line of cases. Specifically, the accident did not occur on tribal land for the purposes of jurisdiction, and the tribal court does not have exclusive jurisdiction under the two exceptions outlined in Montana versus U.S. And third, I think something that is related to this is that the state obviously has adjudicatory authority, it has regulatory authority over its state highways. And for the purposes of jurisdiction, when a state has regulatory authority, it generally also has adjudicatory authority. And in this case, I think that would give it at least concurrent jurisdiction instead of the jurisdiction being exclusive to the tribal court. As I mentioned, we do believe that a lot of the claims arose from conduct on state land. One of those is the negligent entrustment claim, but also these particular defendants were driving drunk across the state for 180 miles. There is ample evidence to show that they had very high blood alcohol content levels. They had open containers in their car. They were reported as speeding and weaving in and out of traffic a mile before they ever crossed onto Navajo Nation, on the right-of-way on Navajo Nation. And they only drove on that right-of-way for 13 miles before they crossed over into traffic and killed the Peña Delgado family.
Counsel, let me ask, it was a horrible accident for all involved. There's no doubt about that. And we are asked to address what could be a dispositive, but a fairly narrow, very much legal issue.
Yes.
arising out of those horrible facts. And tradition, at least, for torts, not for contracts so much, but for torts, it's the specific situs where the injury occurred, right? And that here, as I understand it from the record, but please correct me, is on tribal land where a state has been given by agreement, an easement or otherwise, to operate a state highway. Is that fair?
Sure.
What is the best case supporting your position that state courts should have at least concurrent jurisdiction and that tribal courts should not have exclusive jurisdiction over what, if you were to look at a deed, is sort of very equivalent as tribal land?
So if you put aside the conduct that happened off of tribal land, I think what you have to look at is the Williams v. Lee line of cases. So, Williams v. Lee was the case that established the infringement test for whether the state has jurisdiction. Does that jurisdiction infringe on the tribal members' rights to make their own laws and be ruled by them? The Supreme Court, in years since that decision was made, decided two other cases, which is Montana v. U.S. and Strait versus A1 contractors. And those cases rely specifically on Williams v. Lee. They cite Williams v. Lee as the first example of one of the exemptions when the tribal court has exclusive jurisdiction. So I think you have to look at those cases, and those both tell you that this is not exactly tribal land because it's a right-of-way and the tribe does not have exclusive authority over that land, which is why the jurisdiction should be concurrent. And it also tells you that for the tribal court to have exclusive jurisdiction, you have to meet one of the exceptions in the Montana case. And neither of those exceptions apply to this case. There was no contract, and it doesn't affect the tribe's welfare. Basically that's what it says. So,
Counsel, is in the Montana case, we were talking about land that was owned in fee by non-tribal members, correct?
In the Montana case, that is correct.
Okay, which is not exactly what we have in this case, correct?
Correct.
Is Strait the case that supports your position more clearly on that? Factually aligns with our case or more directly?
Yes, I think Strait is the case that equates that non-Indian land to the right-of-way. So you're talking about non-fee land in Montana, and they extended that and said it's equivalent. If you're talking about this right-of-way, it's equivalent.
So a follow-up question on that. In Strait, we're talking about defendants, though, that were non-tribal members, correct?
That is correct.
Is that important when we look at Strait versus the facts we have here, where we have just the opposite scenario?
I don't think it is, because when you look at other cases that have been decided since then, the court specifically says that it's not. So if you look at the Nevada v. Hicks decision, it rejects the idea that Strait was only concerned with jurisdiction against non-tribal members. The other thing that Nevada v. Hicks finds is that the Montana exceptions apply to both Indian and non-Indian land. So I think that case kind of answers that question. I think the Ninth Circuit has followed that in their the Smith versus Salish Kootenai College case. They applied that test when it was a tribal member defendant. And then, of course, we have a state court case, C. Hare, where this exact scenario happened, and, relying on Montana, Strait, and Hicks, they found that the tribe did not have exclusive jurisdiction.
And I guess the one area that I struggle a little bit is Montana and Strait. As I read them, we're addressing tribal court jurisdiction, and here we're talking about state court jurisdiction.
Yeah, and I understand that, but if you look at even Arizona cases, when they are determining whether there's tribal court or state court jurisdiction, they actually look at both cases. Because if the state doesn't have jurisdiction, then the tribal court has jurisdiction. So there are several cases, for example, State versus Zaman, that was a state jurisdiction case, but they actually looked at Montana and Strait. Begay versus Roberts, that was a state jurisdiction case, and they actually looked at Williams, they looked at Montana in that case. So they're kind of two sides of the same coin. You can't just look at one without looking at the other.
And you mentioned CR, but other states haven't followed CR, correct?
That is true. And we think that CR more aligns with what the Arizona courts do because, first of all, Arizona's tacitly rejected much of the reasoning in the other two cases, which are Weiner and Hinkle, specifically that Montana and Strait should not be applied when decided cases involving state jurisdiction or where there's a tribal defendant. So in State v. Zaman, that was state jurisdiction. In Begay versus Roberts, that was state jurisdiction and a tribal defendant, and they both applied Montana and Strait. Well, Begay didn't apply Strait because it was decided before Strait. But the other thing about Weiner and Hinkle is that they were relying, at least in part, on state court precedent. So part of their decision was that we think our state, has come to a different conclusion, so we're not going to necessarily follow this.
But that's what Arizona's done too, right? Haven't we already decided this issue? I mean, your argument is that we should reconsider.
Well, yes. So you did decide this issue in Enriquez, but at the time Enriquez was decided, we didn't have the benefit of these additional decisions. So the only thing that the court relied on in Enriquez was the Williams v. Lee case, and then it relied on basically a criminal definition of Indian country, which interestingly the Strait Court recognized that that's a definition of Indian country and chose not to use it. So we think that the court should revisit this, particularly because, the state obviously has an interest in regulating its highways.
Counsel, let me ask, related to the CR inquiry and what other states have done, we are asked to address an issue of United States law, right? Not state law.
That is correct. So when it's the federal government that decides what authority the tribe has. So we really need to be looking to the federal government, not to state law.
And understanding that state courts and federal courts alike are asked to address this issue, and at least as far as I can see, there's no one clear North Star. It's sort of stitching things together from a variety of cases issued in different contexts over an extended period of time.
That's correct, and it is very complicated. It's not as straightforward if we were looking at just subject matter jurisdiction for normal purposes. I understand that, and the cases are kind of all over the place, and there is no federal case that exactly matches our fact pattern. I do think the way the Supreme Court has kind of been ruling on these issues, obviously we cite the Castro Huerta case, which is a criminal jurisdiction case and not necessarily applicable unless we're going to continue to apply a criminal jurisdiction standard. But you kind of see the Supreme Court maybe readjusting, how it looks at these issues.
Well, given the split in authority, it seems like to me that the Supreme Court needs to take the case.
They may, obviously you can only go on what they've said so far.
You would just rather be on the bottom side than the top side in that petition. I'm taking it.
I think you probably would, but, I think that the court has kind of signaled that the state may have more jurisdiction over tribal land, particularly because of the changes in Oklahoma. But Just one other thing that I want to mention is that nobody here disputes that the state has regulatory authority over the highway. And I think it's really important to recognize that if you say the state doesn't have adjudicatory authority, that, you know, there's possibly an effect on that regulatory authority. And interestingly, Navajo Nation cited a case, United States v. Cooley, that kind of the opposite situation, where they were saying that the tribal court really didn't have the authority to regulate the state highway because they needed to find out whether they were tribal members first. And the court basically said that that was unworkable. And that's what would happen here if we went to a situation where the tribal court, you know, is the only one that can regulate the highway. I think that creates an issue for the state, which is why we're not saying that the tribal court may not have jurisdiction, but we're saying we think it's concurrent given the nature of the land and, you know, the parties involved. I'm going to reserve the rest of my time.
Sure, thank you.
May it please the court, Susan Freeman on behalf of Century Insurance Company. The court is correct that, in fact, the issue about how much of the actions leading to this incident arose off the reservation was not raised below and was not raised until the reply brief. We would point out that there is actually no evidence as to how long there was any drinking, whether it was for 180 miles or only 1 mile. There is no evidence as to when the alleged negligent entrustment to Mr. Cody occurred. The closest you have is double hearsay of Ms. Grandson telling Officer Nez, who then told the people who were preparing the accident report that she thought that they were coming from Phoenix and that the driver was Mr. Chee, her alleged husband at the time, and then Mr. Cody was the passenger, and that he was in them drinking and texting back and forth with her about the location. But there's no evidence at all as to when Mr. Chee turned over the wheel
Of course
to
there's
Mr.
no
Cody.
evidence. This was granted on a motion to dismiss.
That's right. But my point, Your Honor,
But
is
my
that
point would be that you don't want a factual dispute because that would be a remand for a
that's correct. I'm just, insofar as we have allegations about all of this drinking that occurred when it was on clear state land, we don't have that kind of a record. Number
If that's
two,
dispositive, then we should remand this, right?
I don't think that that is dispositive.
All right, so then let's move on to the legal issues involved.
There is no tort for drunk driving when you're not actually hitting someone, when there's not an incident. There's not a tort. I don't have a cause of action against somebody who's weaving in traffic who doesn't actually hit me. So we don't have a negligent entrustment claim. We don't have a wrongful death claim until there's actually the incident on the reservation. But number two, the point with respect to joint patrol, that likewise was not raised until the reply brief, that the state and the tribal authority had joint ability to control the highway that was over the reservation. What we have here is an allegation. Well, let's see. Number one, the state does have the ability to control by having its officers there. But as the court will see in footnote 11 to straight, the state then, the Navajo officers who are there on the scene, and there were many of them, and they They were patrolling as well, and they were in charge of the highway before the DPS officers arrived. But the DPS officers have the right to, first, the Navajo officers have the right to cite a non-member, and that will then go to the state court. And that's the cases that are underlying the footnote 11 just straight was saying that's what happens. It's when you have a non-member, then the Navajo officers can detain him, and that person would then go to the state court. But then likewise, the opposite occurs when you have a Navajo officer who is there, and it's or a DPS officer who's there, and it's a Navajo member who is the one who is detained. We don't have this in the record because this is new, but and we raised in the reply brief. But I can tell the court that there is a law enforcement agreement between the Navajo Nation and DPS, pursuant to which a DPS officer who arrests and cites a Navajo person, a member of the tribe on the reservation, then is able to cite it to go to the Navajo District Court.
Let me ask you a question on straight. So am I understanding straight correctly that a highway that traverses over tribal land
Right.
in straight, when the defendant is a non-tribal member,
Right.
The right-of-way is non-Indian land? Am I reading that correctly?
I think it's a little more nuanced than that, Your Honor. When you read straight, it says that the right-of-way renders the equivalence for non-member governance purposes of non-Indian land. It doesn't say it's non-Indian land.
Okay. So
It
let me ask you this. Is it I don't want to say illogical, but is it inconsistent then to treat a right-of-way one way if it's a tribal member as a defendant, but it's treated a different way if it's a non-tribal member defendant? Is that inconsistent or unsettling to you in any way?
It is certainly odd, Your Honor. I would recognize that. But all kinds of jurisdictional issues are very odd.
Is that your position, that that's what straight is saying, that it's a narrow holding applying as it applies to a non-tribal member defendant?
Yes. That is only for non-member governance purposes, and the court limited it to that. In Nevada v. Hicks, after that, the Supreme Court said really the main focus is on the nature, the identity of the individual. Is this a member of a tribe on its reservation, or is it not?
Any other area of law where we treat?
But it's important, Your Honor. It's important because we have the underlying treaty of 1868, under which the Navajo Nation has sole authority unless and to the extent that it is taken away by a federal statute, by a federal law. And you have that federal law that took rights away in respect to criminal jurisdiction. You have narrowed with respect to individual members of a tribe when they're completely off of the reservation. But this is the closest you come to an on-reservation action, and it's only with respect to for non-member governance purposes. There are no Supreme Court cases. Didn't find any federal appellate cases either that said that you have jurisdiction over a member of a tribe for an action that is on that reservation, whether it's on a highway or that is patrolled by the state or not. This is you're being asked to really extend the law. You're being asked to step outside. Enriquez step outside of Williams. Williams, that is repeatedly reiterated over and over as being the sound law and remaining good law here, and saying that no, the state has jurisdiction, concurrent maybe, but has jurisdiction over actions of an Indian on his reservation. And is set forth in the Navajo Nation amicus brief, this is really important because that is the right to make the laws and be governed by them. The right to say this is tortious conduct, the right to say this is illegal conduct for another reason. Yes,
Counsel, under the right-of-way here,
right.
does the nation reserve the right to select who uses that right-of-way?
The nation allows non-members to use the right-of-way.
It's actually all non-members, right? It's not, we will let these people through and not these others. It is open to the world.
It is open at this point to the world, but if there is an accident on a highway and it is the person who caused that accident is in fact a member of the Navajo Nation, then even if a DPS officer is the one who cites that person, it's going to be heard in the Navajo courts.
And so that analysis looks at who the defendant is,
yes,
regardless of where the injury occurs.
Well, no, it matters that it's on the reservation, but not in the city of Phoenix, but it's on the reservation.
Help me better understand that, because that's such a really thin read. The difference between injury on land that the nation can't exclude people from versus injury just across the boundary from the reservation.
But that is a line that has been drawn repeatedly in U.S. Supreme Court cases.
What's the clearest case in this context? Because I think there are rights of way granted by tribal nations in many locations that applies the analysis that you would suggest we apply on these facts.
Well, on these specific facts of driving on a reservation, you have the Weiner and Hinkle cases, the ones that are ruling opposite to Saher, that are
and
dealing with that.
Sahara, of course.
That's right. And Saher, that's going the other way. I would note that the State v. Zeman case is in fact after Strait, and that was one where the court said the Williams tribal infringement test remains the law here in Arizona, that's our Arizona Supreme Court, and protects individual tribal members, not just the tribe, that you're still dealing, when you're dealing on the reservation, this is the land that remains Navajo. They've given rights to the federal government otherwise under the treaty, but this is their land.
Well, and kind of to the world through the right-of-way, right? To use the highway.
To use the highway, but not to take over and haul into a court in Phoenix or somewhere else that's off the reservation where it's not the Navajo Nation laws that are governing. It's not the Navajo Nation defendants.
And I want to ask you about that.
Yeah.
For a traffic accident. Now, you mentioned, I think, a traffic citation. Mm-hmm. Those are treated differently, apparently.
Well, no, I mean, I guess it's really...
Let's say there's a civil traffic citation on this chunk of the highway. What court does that go to?
If it is a non-member, then it goes to state court.
Okay.
If it is a tribal member, it goes to tribal court.
What happens in this case if the ruling finding no subject matter jurisdiction stands? What options does plaintiff have?
Effectively, well, the plaintiff has the right to go to tribal court.
Sure. And what would the body of law for that decision be?
The Navajo Nation Code, we've cited portions of it in our brief, but there is a legitimate, long-standing code. They could appeal something up through the Navajo Supreme Court if they.
And is there a limitations issue that would be created if that's required, or would the saving statutes of the state of Arizona apply?
Your Honor, I don't know the answer to that question.
And I don't either.
Yeah, I'm sorry, that's not one that I thought of, so I didn't research that one in preparing for this argument. I don't know the answer to that one. But there certainly is an ability to bring a tort suit and something that they should have done in the first place if they wanted to do that, just like they should have filed for probates in the Navajo probate courts.
Well, and I understand your argument, but the issue that your client raised came in fairly late in the judicial day in this case, right? I mean, it had been pending for kind of a while.
But they were warned at the outset that they needed to take these actions. And
How long had the case been pending before your client moved to intervene? Year and a half, maybe?
I do not know the answer to that one. I'll ask my counsel,
That was really
to
my
answer.
point.
But yeah, they had repeatedly tried and to communicate their concerns, to communicate exactly what needed to be done. They had told plaintiff's counsel repeatedly, you need to file these actions in Navajo tribal court, and that's what the record shows. But they didn't do that. Instead, they went to 3 different courts in the state system instead. I guess I do want to make a couple of additional points here. One, with respect to the Smith v. Salish Kootenai College case, footnote 6 of that is one that you might otherwise overlook, but it says that there was concurrent jurisdiction in Montana at that point in time of both the state court and the tribal court because of actions under Public Law 280 where the tribe and the state had reached an agreement. However, that ended up getting reversed by the same state Supreme Court later after the State v. Salish decision. But State v. Salish says Williams is still good law. Weiner, again, the post-straight case that is saying that you have to have jurisdiction, only tribal jurisdiction, that is good law in some other states. But not in Montana because we have the concurrent jurisdiction there, as I said, since reversed. But when the court underwent its analysis going through the Montana exceptions, it still came to the conclusion that you can't take over the body of law, in fact, filing suit in tribal court, that the tribal court had jurisdiction because denying it would seriously limit the tribe's ability to regulate the conduct of its members through tort law. So it came to the Montana answer, but it didn't need to go through that. We don't need to go through it because in our situation, Williams applies, and the Smith v. Salish case determined that or recognized that as well. With respect to, let's see, I guess one of the points that they had indicated was consent to jurisdiction. That was something that was also raised in the reply brief. That was, again, not raised below, not raised in the opening brief. And, of course, subject matter jurisdiction, you can't just consent to when you don't have it. And the Williams case made very clear that you don't have, that subject matter jurisdiction is determined by the location on the reservation and by the identity of the defendant. And then you have the Kennerly case from the U.S. Supreme Court that says, likewise, consent is not enough unless it's consent under Public Law 280 and you follow all the right steps. And if you don't follow all the right steps, you don't have consent, and therefore you don't fit within the congressional exception to the rule. Does the court have any other questions for me? All right, I guess I would end then by saying that the Navajo Nation does have exclusive subject matter jurisdiction. It matters, as set forth in the Navajo Nation's brief. They're the ones who make the decisions as to what law applies, and they have the Navajo Nation members have the right to defend under that law and be heard in their own courts. And that includes actions that are on the reservation on a part where there's some regulation by the state, some regulation by the Navajo Nation on an easement that traverses land. And this court should not step out of Enriquez and step out of Williams and go where No other court except Sahara has gone before. We think that it's not well reasoned. Thank you, Your Honor.
Thank you.
So I want to address a couple things. First, we're not saying that Williams is not good law. We're not making that argument at all. We agree that the test still applies. But when you look at both Montana and Strait, they rely on Williams and cite Williams as one of the cases that falls within the first exception that Montana sets forth related to tribal jurisdiction. So, and obviously the facts in Williams were very different to the facts here. There was a contractual agreement that the plaintiff had with, essentially with the federal government to sell on the tribe. The transaction took place on the tribe. You know, that falls under that first Montana exception. In response to Salish Kootenai College, I think it's important to realize that the Ninth Circuit applied Strait to a tribal defendant. In that case, it was a tribal defendant, and they found, for the purposes of jurisdiction, this right-of-way is non-tribal land under Strait. So it's not just that the state court has done it, the Ninth Circuit has made that finding as well. If the defendants were bringing the action here, if they wanted to sue the Peña Delgado family for some reason, they would have to go to state court. And that creates kind of an issue, which is why we think concurrent jurisdiction is appropriate. There's two cases out of the Ninth Circuit, Burlington versus Red Wolf and Wilson versus Marchington, which basically say that the tribal members would have to go to state court on if they were on a right-of-way and hit by non-members. I know you asked me about, you know, don't we look at where the conduct occurred? But when you're performing a conflict of law analysis, which courts often do when they're like trying to determine whether another state has jurisdiction or this state has jurisdiction, the court does look at the place where the conduct causing the injury occurred to be the most relevant factor, and the place of injury was merely fortuitous, then you know, that state would have jurisdiction where most of the conduct occurred, and that's the Pounders versus Ensearch case. The other thing I want to bring up is that the tribe was paid for and received compensation for the right-of-way. That was pretty critical to Justice Ginsburg's decision in Strait, was that the tribe had been compensated for it. They had given up their rights to control the highway. They had no gatekeeping right. They found that it didn't, they applied the Williams test and said it didn't infringe on, you know, tribal members' rights to make their own laws and be ruled by them. So I do think it's applicable here. Last, on the fact of that there's no evidence when the negligent entrustment occurred, we do know that based on the police report, that there was a report that the driver was already speeding, already weaving in and out of traffic before he ever crossed onto tribal land. Sure, we don't know where between Phoenix and there it happened, but given the multiple reports that he was driving erratically, it's pretty clear that that negligent entrustment occurred off of tribal land. Additionally, their blood alcohol level, which was a 0.33 and a 0.42, like they were drinking for hours. You just don't, I mean, that's 20 drinks, 10 to 20 drinks a piece. You just don't get that drunk within, 13 miles driving on Navajo Nation. We don't dispute that the tribe has concurrent jurisdiction over the highway to regulate it, but we think that's why concurrent jurisdiction and not exclusive jurisdiction makes sense here. Thank you.
Thank you. Council, thank you for your arguments today and your briefing. Thank you also to the Navajo Nation for the amicus. You've given us much to think about. We will take the matter under advisement and issue a ruling in due course, and we are adjourned.